Great. Okay, so good morning, everyone. The faithful few that we see, we're glad to have you. And we're here this morning to talk about case 2225, which is some really impactful changes on procedures at the Zoning Commission and at the BZA that the community needs to be aware of. And we're happy to have this opportunity to sort of learn a little bit more and build our shared capacity. And before I turn the stage over to Alex from the Office of Attorney General and her colleagues, we wanted to just have everyone have a brief opportunity to introduce themselves, maybe what ward they're from, and maybe one thing that they're looking forward to hearing or concerned about. And why don't I start? I'll just take prerogative and I'll call on Ron Khan first.
All right, thank you very much, Paul. I'm a resident of ANC 34G, and we're in one particular interest is we're in the process of implementing over a long period of time a small area plan. So it obviously has to do with a lot of zoning types of situations that we'll be involved with. So I'm not an ANC member. We do have an ANC member on the call, but I'm trying to take that all in terms of the impact of 2225. Thank you very much.
Thank you, Ron. Peter, thank you so much for pulling over and being with us today. Commissioner Gosselin. I think you're muted, I think.
Tap to speak. Can you hear me?
We can, yeah.
Good. I'm in a Dollar General store parking lot, so on my way back from Syracuse University. I'm a commissioner with the ANC 34G. As Ron said, we've gone through a year plus of a small area planning process. And if I understand this correct, and we tried to speak loudly about racial and social equity. If I understand this case correctly, it basically absolves OP of notifying ANCs of map and text amendments, which to the extent I understand zoning is basically the way business gets done. And it sounds like it exempts a whole lot of stuff from any sort of racial equity review. And both those things disturb me an immense amount. Thank you.
Thank you, Commissioner Gosselin. Ms. Gates, Ms. Alma Gates.
Yes, Alma Gates, Ward 3, former ANC commissioner, just been redistricted out of my my home, so to speak, and put into a district that's like a hanging chad. It's 2 blocks long where I live, and then connected to a larger area with which we have no relationship. I'm also a member of Committee of 100 and active there on the zoning committee.
Great, thank you. Ra, Commissioner Ra Mean, would you like to?
Good morning, everyone. Good morning, everyone. I'm here in Ward 5. I turned off my camera to get a little more bandwidth here, so I won't screw up our audio this morning. But I'm here in Ward 5. And, you know, I'm no expert by any means. I'm an ANC commissioner that's running for re-election. And I'm here trying to learn as well as we move forward.
That's perfectly fine. Thank you. Thank you for being with us.
I'm done, Paul.
No worries. Thank you. Thank you, Rock. I know there's some people that are off camera. If I'll call your name, if you're able to unmute, that's fine. If not, that's okay as well. Miss Tamara Duggleby?
Yes, I'm in Ward 3.
Okay.
And I have a background in community development finance in major cities. like Chicago and DC. And my main concern is the effect of this non-notification of people like us that a zoning proposal is going to be made and try to push through that would affect people's housing. A long time ago, I worked in Chicago with housing and urban development. I was one of the authors of the Section 8 subsidy program in '74. And I went on to work with the RESCOR, with the Research Corporation of the Chicago Savings and Loans, to develop mixed income housing in South Shore and other places. And we developed it successfully, and we were able to preserve the zoning. I know it can be done, and I would like to help in any way to make sure that changes, regarding that particularly are not pushed through.
Fantastic. We appreciate that background. I'm looking forward to it. Commissioner McWood, Nancy, did you want to? Sure.
Sure. I'm really happy this briefing is happening. I'm Nancy McWood. I live in Ward 3. I've been an ANC commissioner in the Cleveland Park area for over 20 years. I'm not running for re-election this year. And I'm involved with a variety of affordable housing, planning issues, zoning issues, both in Ward 3 and across the city. And I am coming a little late to 2225, although it's been on my radar, but there are so many other issues as well that are percolating right now that I really appreciate getting a little boost here so I can jump into this issue. Overall, I would have to say I am increasingly alarmed, frustrated, and annoyed by the Office of Planning and how hard they're trying to make it for all of us, whether we're ANC commissioners or residents or activists or people who care about the city. Their text amendment campaign, which has been going on now since ZRR in 2016, has just got to stop. And notices have to be more democratic and more comprehensive. And somehow we have got to get it through to the Zoning Commission that the Office of Planning is really working against us. Thank you.
Thank you, Nancy. Appreciate that. Ms. Rochelle, Sini, would you mind introducing yourself and stating, I think you're on mute. Good to see you.
Hi there. I'm Rochelle Sini. I am a resident of Ward 4. I am a born and raised resident of Washington, D.C. And I'm on the meeting interested in the topic to learn more. I'm expecting you all to educate me as to why the Planning Commission is rezoning everything. It seems like every 5 minutes, but I'm here to get educated. Thank you.
Thank you, Ms. Rochelle. How about Will from DuPont South? Is it Herzig? Commissioner?
Everyone, I'm surrounded by folks, so I'm going to be quiet. But yes, Will Herbig here, DuPont South. In addition to being a commissioner, I'm also a planner and urban designer, work at the Urban Land Institute. So this is a personal passion and a professional passion, but mostly in listening mode today, as I'll take this and report back to our land use committee. And the commission may have some formal comments based on what we consider. Thanks, everyone.
Fantastic, glad to have you. Was there a Deidre Brown on here earlier? She might have dropped off. Okay, Commissioner Bowser, Renee Bowser. Did you ever like to introduce or have a comment?
I don't have any comment. It's just that I was discussing this with another commissioner yesterday. Seems like not that many people know about it.
Yep.
But I'm Renee Bowser. I'm a commissioner, longtime commissioner in Ward 4, Petworth, and this is my last term. And just trying to print it out yesterday, just trying to learn so I can see where, bring my knowledge of what's happens on the ground to what they're suggesting.
Fantastic.
Thanks.
Thank you, Renee. And Ms. Tawana Baylor, would you like to introduce yourself? Maybe state what you're looking to gain today? If you're speaking, you're on mute. Ms.
Apologize. Good morning, y'all. I'm gonna have the word. I'm old school. I apologize. And one of the kids that I look out for in my community died last night, so I'm a little bit all over the place. He wasn't the one I gave money. God be the glory to send to college, and he passed. So I'm listening.
Yes, ma'am. Well, thank you for being with us. And we appreciate you. Lastly, I think there is Ms. Tyson, Sheila Tyson. Did you want to introduce yourself? Maybe say what ward you're from, what you hope to learn today?
Yes, good morning. I'm with the Metropolitan Women Democrat Club, and I'm in Ward 5, raised in Ward 4, native Washingtonian. I'm very interested in the subject matter.
Yes,
So I'm
ma'am.
going to report back to our club members.
Very well. Thank you so much. I believe that's mostly everyone that expressed an interest to speak. If there aren't any. I'm sorry, I couldn't hear who that was. If did you want to?
I heard her speak from what ward I'm from.
Ms. Baylor, you were breaking up a little bit. Ward, which ward?
Ward 8.
Ward 8. Okay, thank you so much. And Ms. Sabrina Rhodes, I'm sorry. Did you want to introduce Commissioner Rhodes, Ward 5?
Good morning, everyone. I'm ANC Commissioner here in Ivy City, also organizer with Empower DC. I've lived all over DC and other than Southwest, but I just like Parisa said earlier, we need to throw a wrench in these shenanigans and make sure that the residents of all the wards are being protected, starting with the ANCs having Great Lake.
Great, thank you. Let's move to the presentation now, and we will hand off the stage to Alex Kane from OAG. I think, Chris, are you going to share the screen?
All right, just made you co-host, Alex, so you can.
Okay, cool.
Okay.
All right, you all able to see my screen?
Yes.
Okay. All right, so first of all, so glad to see so many people here today and see that some people are interested in this topic. It's certainly one that we have been watching and sort of keeping an eye on, because it does have, a lot of implications, both in what is currently being proposed and just sort of the concept of looking at the procedural regs broadly. This is sort of a unique opportunity to really take a look at how the regs currently work and see how they can be made more accessible and more understandable for people. Zoning is a world that we operate in and are familiar with, but are completely aware, and Lily is the newest member of the team, can attest to this. that for normal people trying to figure it out, it can be really, really difficult. So we were sort of viewing this as a way to really maybe try and make those regs, easier for people to understand, and so people are able to participate with greater ease. So sort of going from there, here. 2225 is, to give you a little bit of background, has been sort of in the works for a while. This is sort of the most current iteration of it, and it's proposing to do a number of different things. So sort of broad themes that we think people should sort of keep in the back of their mind as we go through this are these 4 sort of principles. So first of all, the accessibility of the regulations. Are they understandable? Can you sort of track what's going on? Are they understandable for normal people? Equity of participation. Do they allow for people to participate, equitably, fairly? Consistency. We'll see that as we go through it, that there are things that are sort of internally consistent. There are parts of the regs that have not been updated to capture the current language of the regs that they are supposedly amending. And then finally, support for the racial equity goals and anti-displacement goals that are expressed in the comprehensive plan. So that seems to be, the racial equity component seems to be a common theme of interest here. So we will touch on that in a second. So in terms of what OP is specifically trying to change with this, again, we sort of broke this into 4 main categories. So there's notice, public participation, the requirements for map and text amendments or the rulemaking cases, modifications, and then we'll end by discussing sort of some of the things that we're thinking about proposing as part of this. Okay, so to start with notice, and I'm going to run through this relatively quickly. If you have questions, probably just save them for the end and then we can go back, but it is a lot to sort of digest. So in terms of the changes, they are now proposing to provide sort of enhanced notice to tenants and condo boards. So that is a new addition. However, they are also proposing to not provide notice to any ANCs that are pre-redistricting, so that if an ANC was a party to, a PUD case, that PUD comes back for a modification and the ANC boundaries have since changed, the old ANC will not be given notice. It'll only go to the current ANC. They have also now officially excluded August from the calculation of the time periods. This has been sort of an informal rule that the commission has abided by, but they are now making that a formal process. So August no longer counts, for a 30-day notice period or anything like that. It's just sort of a blank. And then finally, that no step down meeting is to occur no less than 35 days after the application is served on the ANC. So sort of, again, the questions we have on the side are sort of things to start thinking about. So in terms of notice, based on your experience as ANC commissioners, as members of the public, when in the process should notice be given? Should it be tagged from when it comes in to the commission? Should, how should the time periods run? Is the notice that's currently being given sufficient for the ANCs to, process something, go through your own internal process and issue a report? Is it sufficient notice for your constituents, for the general public? That's all stuff to sort of be thinking about at this point. In addition, sort of what form should notice take? Right now, you get the mailings that are sent out from the Office of Zoning. There's the posting on the property. There's information available online. How can that be improved? Can the signs be made bigger? Can they include a QR code? How can it be made so that people have a better idea of what's going on? Because anybody who's ever sat through zoning commission cases, and I think even more particularly board cases, knows that the issue of notice and not, knowing that a project is live and going on comes up a lot. And sort of more broadly about the website, is the website as it currently stands useful? Are you able to find information? Are you able to find the regulations? Are you able to find cases? That's all things that sort of go into this idea of accessibility as part of the notice process. For public participations, so the filing deadlines, and I can give you the specific code section, and I believe this is only on the commission side. This is what I was saying earlier about consistency. The regulations as they are currently proposed in this document do not reflect changes that were made as part of the COVID-19 updates. And so it's just, they're referring to time periods that are currently not in effect, which adds sort of a level of confusion as to what they should be. All filings are now proposed to be done electronically, so no longer bringing in paper copies. Everything will be done through ISIS, the web portal on OZ's website. So again, questions to think about, when does it make sense to file comments? What is the preferred method of doing that? Are there issues with doing everything electronically? Does that bar certain people from participation? Does that add hurdles? Should there be, a backup method for that? And other concerns with that as well. Moving on to, again, sort of another aspect of public participation. So they're in the current amendment, they're proposing that reconsideration of the zoning commission's decisions will only be available to parties to the original case. Currently, anyone can file a motion for reconsideration. So that will now be limited to only people who've sought party status as part of the application process. Again, that sort of opens up questions as to how the party status process is working. How accessible is that for people? That has its own set of deadlines and requirements. Are those understood? Do people understand sort of how to use that as part of the process? And does this limitation, make sense, especially considering that to bring an appeal to the Court of Appeals, you don't have to have been a party to the original case. So again, something to consider as to what this does in terms of participating in cases. And then moving on to what seems to be sort of a hot button topic with this group, the map and text amendment requirements. So currently as written, the map and text amendments are not subject to the requirement for a racial equity analysis to be provided. This is required for all of the other case types. You'll see it's been added into the application requirements. It's not clear in looking at it if this was, truly just sort of an innocent oversight in the drafting of the amendment, or if there was, some sort of thought process as to why this shouldn't be included, but it is currently not included as a requirement for those case types. In addition, the amendments initiated by the Office of Planning and the Office of Zoning, so either map or text amendments, are subject to only a very limited set of requirements. And they're just sort of, I want to say the baseline requirements of, the number of votes needed for it to pass, that fees have to be paid before it can be processed. It's not subject to additional requirements for notice or a set down report. Again, it's not entirely clear sort of what the rationale behind that was, but that is the way they are currently drafted. So again, just some notes there about racial equity. I think a lot of you were sort of tracking and participating in the roundtable last week. But in terms of the map and text amendment procedures more broadly, that's something that we have certainly heard is sort of a stumbling block for people, even people who are relatively familiar with the zoning process, that, text amendments particularly can be difficult for people to sort of understand exactly what's going on and understanding how they can participate and what they can do. So I think that's something that, it would be interesting to see, what ideas people have to make that process more accessible to people, because that, really is one of the more important things that the commission takes up. I mean, those are the regulations, those are how these things are made manifest. So having them be more accessible and understandable to people, we think is really key to making the process more democratic. And then in terms of modifications, so as some of you may know, currently modifications are classified as minor modifications and modifications of significance. Minor modifications do not require a hearing, whereas modifications of significance do. The current regulations have some criteria as to what types of modifications fall into which category. So minor modifications are, minor changes to the plans, things that don't really get to, the heart of the decision that was made by the board or the commission. Whereas modifications of significance are changing sort of fundamental aspects of the case. So example, in a PUD case, it would be changing the proffered benefits or something like that, that would require the commission to go back in and sort of reopen and reconsider that aspect of the case. In the current draft of the amendment, they have just now been classified as modifications with a hearing versus modifications without a hearing, but there are no real standards or, guidelines as to what kinds of cases would fall into either of those categories. In addition, there are some implications for notice, especially for the ANCs, as to when the commission could actually take action on these. So that's another thing we wanted to call out there. And then in terms of sort of things that we're looking at and, potentially maybe filing on, again, it's sort of this broader question of organization and accessibility. Do the regs make sense as they're currently laid out? Can they be made easier to understand? We have been doing research into the zoning regulations in other jurisdictions, looking at things that they do, which include, including more charts, more graphics, more sort of, timelines that break down, how the process proceeds and have that shown visually, which we thought was kind of interesting. Looking at PUD benefits to see if there's a way to sort of make clearer what is consistent with the comprehensive plan requirements, especially in terms of affordable housing and anti-displacement. Looking at things like fees for rescheduling the hearings, to see if there are ways to sort of make, expedite the process in ways, but, that still allow for fair participation. And then we also have our two sort of pending procedural amendments of our own. So there's 2205, which deals with tenant protection and anti-displacement measures. So the sort of the outline of what is included in that amendment is there. And then we also have 2215, which had to do with sort of limiting time extensions, particularly for PUDs, and ensuring that if multiple time extensions are sought, that they are brought into compliance for inclusionary zoning and green area ratio requirements. So, looking and seeing if there are aspects of those two that we propose to be incorporated into this as well. And then finally, in terms of next steps, I think it's important. So the 29th, it is currently proposed to be set down. So the commission will be deciding whether to set it down for a public hearing. This is really the start of a much longer process. So one thing I wanted to sort of make clear today is this is by no means the only opportunity for public comment on this. This is really a key moment for ANCs because at set down, the commission is required to consider set down reports from the ANCs as well as the Office of Planning set down reports. So that's clearly spelled out in the regs that they do have to consider that at set down. But there will eventually be a public hearing, which will allow for both written and oral testimony. And then, once the commission moves and takes proposed action on a proposed text, there will be the formal notice and comment period that runs as part of the sort of the formal rulemaking process. So this is sort of, like I said, the start of a much longer process of public participation. But again, given the implications that this has for participation and notice and sort of these broader themes, we thought it was important to sort of get the notice out there to people and to have people start thinking about this, both from the perspective of the ANCs, from organizations, but also just as members of the public interacting with the zoning regulations and the zoning processes. So I think that's everything. I'm gonna pause and catch my breath for a minute. Lily, I don't know if you have anything that you wanted to throw in at the end.
I think you covered it for now. I'm sure there's questions. There's a lot that 2225 covers. So I think we can hand it over to questions. Thanks.
Okay.
Yeah, that is a lot. It's really dense, important. And a lot of questions. I mean, even going through the questions, a lot of the questions. So are there any, oh, Commissioner Gosselin.
Yeah, can you hear me?
Yes.
Good. Alex, you said that the proposal is to exempt OP and OZ initiated amendments. Can you give me a sense of sort of the fraction of business that the commission does that is either OP or OZ initiated? Does that mean most stuff coming to the commission, the ANCs, or they no longer have to notify the ANCs, or is that just a small fraction of the business that comes to the commission?
So it's definitely a high proportion of the rulemaking side of things. So again, the map and the text amendments. Map amendments, I think, sort of based on what we've been seeing currently, are about maybe 50-50, maybe with a slight edge to ones that are initiated by the Office of Planning. I'm not really sure. So Office of Planning initiated map amendments, and then private sector, property owner text amendments. Or map amendments, I'm sorry. Text amendments have been almost exclusively provided by the Office of Planning. We have proposed a few. I believe there have been a few that have come in fairly recently from members of the public. But that really is has been the sort of main domain of the Office of Planning.
And then the other question is this. I mean, to a newcomer, you could say, well, these are two pieces of business, but from a vast array of types of business. My impression is that other than PUDs, map and text amendments are what the zoning commission does. So isn't this effectively saying we're no longer going to notify the ANC of sort of the heavy half of the commission's business?
As currently written, it does have very severe implications for the notice given to ANCs in those cases.
Great. Right. And then I just asked you for both the racial equity review and for this proposal not to notify the ANCs, could you give me a rational reason for exemptions? I mean, what if you were making the argument for this, what would you say?
I truly don't know, Commissioner Goslin. I don't know. And I mean this, and as I've said, and I do want to be clear about this, this is sort of goes to my point that I'm not sure if this was a deliberate step, just because I can't see sort of a rational basis for doing so. And I think there are sort of broader legal implications in terms of the ANC Act and the APA and things like that. So like I said, it may very well have been that this was just an error in drafting and it was left out of the sections. I don't know. But it is nevertheless a question that needs to be resolved because of the implications that you've just indicated.
Okay, and then I'm sorry, one other question. I'm sorry, Commissioner Johnson. I'm trying to. Is the business about not notifying? So we're at the end of a small area planning process, and the Office of Planning is now drafting the language for a special zone for the Upper Connecticut Avenue commercial corridor. If these rules were in place, and they're doing that at our behest, I mean, that was put into the small area plan at our commission's behest. If these rules were in place, does that mean they wouldn't notify us of that? Or they would have no requirement to notify us of that?
As currently written, assuming that these were in place by the time, currently written as is and in place by the time that came through, no, I do not believe that they would have to, just based on the way it's currently.
That's a kick in the pants. Okay, thanks.
Wow. Thank you, Commissioner. Commissioner Rhodes?
Yeah, Commissioner Goslin just stated what I wanted to ask. Why now? Why are they doing this? Like here in Ivy City, we getting ready to start out planning for the small area plan. And it just seems like OP is trying to go around the comp plan and trying to go around the community engagement. And they're trying to stop us from making sure that our communities are the way we want the communities to be. So because OZ had the roundtable last week, which I feel like was just for show. I don't trust zoning and I don't trust the Office of Planning. Do we think that once we put in these public comments, is that going to change anything? And what gives Alex, this question is for you. Because you all are working so closely on this case, what gives them the right to just kick us out of all the plan, everything, especially the map and text amendments? Because what it seems like to me, and I'm not a professional at all, and then there's a lot of ANC commissioners that don't know anything, are not aware of none of this. So this is just going to go over top of their heads. So I'm trying to figure out, is the reason why they're doing this and they're doing it so fast is so that it can go over top of everyone's heads and they can just slide it in and it'll be law. What is the intent? What is their intentions?
So I can't speak for what the intent of the Office of Planning or the Office of Zoning is as I was saying to Priest a little bit earlier, the idea of doing a procedural text amendment that deals and tries to clean up some of the procedural rules has been being kicked around for a while. This is actually sort of the second coming of an earlier amendment that was proposed back in 2019. So this has been around for a while. This is, as I said, this is just sort of when it's coming forward. In terms of, you know, the ANCs participating, as I said, I think the importance, and I know we're sort of really coming close to the deadline for filing for set down, but, you know, sort of intent or no, there are a lot of questions with the way that this has been drafted. So as I said, even if, you know, it was purely an oversight not to include those provisions, that's something that should be, you know, asked of the commission, you know, what was the reasoning for behind this? These aren't included. That seems kind of strange. Can you ask the Office of Planning to either provide a justification as to why that was done, or, you know, correct it if it just was an oversight? So, I mean, I think this is, and, you know, I think, again, this raises sort of broader questions as to, you know, giving people a chance to say, you know, we want to participate in this. We don't really understand, you know, what all is being proposed. We get some of it, but the way this is written, the way, you know, the lack of explanation as to why these things are being proposed makes it very difficult for us to participate. And we think that that is something that should be addressed. So there's, I think, sort of the way to look at this is both specifically what's being proposed in this amendment, you know, both, you know, any questions, any, you know, potential issues that you see, but also sort of more broadly, what do you as an ANC commissioner, you as a member of the public, think should be included or changed to make this whole process understandable? And I think that is something that, you know, the more people that can start weighing in on that, I think it's, you know, power in having more and more people come and say, this is not a clear process. Like, we need to have this cleared up so that more people can participate and that participation can be fair.
Well, will this, once we submit our public comments, will that change anything, or are they just going to just do this process without us, and we're just working in vain?
I mean, I would hope with something like this that has such real implications for how people can participate. And I do think that the commission and the board, based on my experience, I think they are very concerned about having public participation. So I think, you know, making it clear that this has real impacts on that, that is very important for them to understand, and to understand, you know, where there are these issues or these omissions or whatever they may be, so that they know, you know, they can then direct, hopefully, the Office of Planning, as I said, to go back and say, you know, you need to clear up this section, this needs to be explained or clarified.
So the main part that we need to put in our comments, and this is my last question. So the main thing that we need to put in our comments is the changes that are being made that is leaving the public out, the ANCs out. That's the main thing we need to focus on our statements.
I think for anything that goes in right now, the main focus should probably be, you know, these are what we see as the main errors right now. These are the things that just are really burning questions that have to be answered. Like I said, this is not the only opportunity to do that. I know everybody has, you know, there's a finite amount of resources that people have, but I think in terms of sort of marshaling them, I think at this point it's trying to get clarification on those issues, and hopefully, you know, that resolves some of them going forward. So then by the time we get to the text that's proposed for the hearing itself, it's hopefully, you know, a little bit cleaner, and we can focus on some of these broader issues.
Okay, thanks.
Great. Thank you, Commissioner Rhodes. We have about 20 minutes left and 3 people in the queue. Commissioner Gosselin, then Commissioner McWood, and then Commissioner Bowser.
Alex, during our small area planning process, you and colleagues offered to, told us about a sort of change in mandate for your office within the Office of Attorney General, and offered your good services to help us in these areas. I don't want to, and in fact, I took your colleague up on that in a big time in the late going of our small area plan. I don't want to short circuit the process. We will make comments. We will work the set down procedure. But You said in your presentation that there were important legal issues of mismatches, potential mismatches between these regulations and the ANC law. Is your office, can your office provide us legal counsel on that? I mean, and in the extreme, if we do not get changes here, explanations and changes here, would you be willing to represent us in challenging a regulation that if it looked like what is currently being proposed?
So at this point, I mean, any intervention or representation that we do would have to be cleared by our immediate office. So I think it would sort of depend on the situation at that point. At this point, I think what we can provide is information as we are today. You know, we can provide additional information about, you know, what the requirements of the ANC Act are and sort of where they come into conflict with this. I think anything beyond that, we would have to sort of see down the line how things sort of shake out. So.
Okay, good, thank you.
This is a question for Alex and also Lily and Parisa. The first part of my question, I'm not going to ask because Commissioner Rhodes already covered it. So my understanding is that the focus, because this proposal is so dense, that the focus before set down should really be on the big issues like notice, and so that the zoning commission can try to challenge the Office of Planning as to what their intent is and what the implications are. But I'm also really interested in the racial equity piece, since we just had the roundtable last week. This is prominent in the zoning commissioners' minds, I would hope. Also, Chairman Hood has been talking recently about trying to improve participation, expanding notice, using plain language, and this is the antithesis to that. But I'm particularly interested in what the implications are for racial equity regarding map and text amendments. How would it be important to have a racial equity analysis for those two processes? And what does it mean to exempt those processes that have never even been included as yet?
Yeah, so I mean, in terms of the requirement for a racial equity analysis as part of those case types, you know, as I think multiple people made clear in their testimony last week, per the language of the comp plan, the racial equity tool is supposed to apply to all zoning cases. That's clear in the language of the comprehensive plan. I will say in terms of actual practice, what we have seen, you know, in set down reports from the Office of Planning on recent map amendment cases, that they have been including them. So again, that goes sort of to this point that I'm not quite sure sort of what the thought process here is, or if it is just sort of an error in drafting. But the broader issue of racial equity, sort of beyond, you know, the requirement for a report or a analysis to be included as part of the applications, is this idea of, you know, how is this process accessible to people? And I think one of the clear examples of that is this idea of, you know, all the filings are now going to be electronic. That makes sense in a lot of ways, but until you start looking at, okay, what is the breakdown of computer access, of internet access along racial lines, along economic lines, and then that starts to raise real questions as to, you know, has this really been considered, has this amendment itself been considered through a racial equity analysis? So that's what I'm saying. There are sort of these broader, I think this in a certain way should be viewed as sort of part two to the racial equity analysis tool that we were discussing last week. This is sort of the procedural part of that, and that is something that has, you know, come up throughout this whole process. It's certainly something that CORE raised in their analysis of the comp plan. You know, they did sort of raise this issue that, you know, it's fine to put in this requirement for a tool, but there are additional changes that need to be made to make the process as a whole fairer. So I think that is something that has to be considered sort of beyond just the requirements for the analysis itself to be included, to say, you know, wait a minute, is what's being proposed here writ large fair from a racial equity perspective?
Yeah, I would just add that, all of the definitions in the comp plan around racial equity and equitable development really emphasize meaningful community engagement, and the ability of the community to be informed and involved in the decisions that are being made. From my perspective, I understand that the commission may be able to envision analysis of a specific project, but not analysis of decisions that impact a broad swath. Either it's, through changing the rules or changing the maps in a broad way, but we have to do that level of analysis because that's the key places where the meaningful involvement is really decided. In Berry Farm, they did a map and text amendment for the site that will essentially now allow, whatever development to occur over the next 10, 20 years with no further PUDs. And so that means that, there really isn't going to be other actions at zoning that the residents can use to be heard and ask questions, try to seek accountability around right to return, around affordability levels, things that may arise in the future. We no longer, I think, have the zoning process as a process that can be used to elevate those concerns. So I would say that in and of itself is racially inequitable. It's eliminating a channel for community members to be involved. Yeah, I think this is really problematic. And I would like us to look back at also the text amendment that OAG developed, the ideas of automatic standing for residents, tenants within the impacted site. This is another thing that's, come up again a lot because I think it's just the owners that have the standing. The notice has not been given to public housing residents. It's given to the housing authority or, some bigger, broader tent, but the residents themselves are usually not informed and not given any kind of, formal notice, and they should be. It's their home.
There's a question from Renee or a comment from Renee, and then in the chat from Ms. Rochelle Sweeney, which we'll go to after Commissioner Bowser. Renee, go ahead.
Thank you, Commissioner. I wanted to ask, what is the date that the record closes? Because I think I can get my ANC to do a resolution on this. I would draft it, but we don't meet till the third Wednesday of October, and the commissioner I was talking to yesterday, who checks the DC Register every week, was unaware of this hearing. So I just, how can we try to draw the, have time to talk to the other commissioners, because I think I can convince them of this. And what it seems to me is that to make the circle narrower and narrower, they'll have us spinning our wheels when someone wants to build a deck on the back of their house that's a little bit larger than the, has more of a, takes up a little bit more of the yard than the regulations require. And to get people to believe that's community input and they're having some real effect on zoning issues in the city when the big issues are being kept away from us.
Yeah, so what is happening this Thursday is a set down meeting. So this is just the commission reviewing the initial draft text, any comments from ANCs that have come in. So I think there shouldn't be any sort of hard deadline on the ANCs to file things for Thursday. So anything that's in the record from ANCs, whenever it comes in by 4 p.m. this coming Thursday, they will consider as part of their decision as to whether to set this down for a public hearing. They may decide not to do so. They could say, we've gotten enough questions from the ANCs. We think this needs more work before we'll set it down for a hearing. Or they could decide, to resolve that, between set down and the hearing itself and move forward and say, okay, we're going to schedule this. I think at this point, you'd be looking at a hearing on the draft text probably sometime in January or February, depending on sort of where their calendar is, but you'd have a couple months between set down and when the actual hearing would be. So as I said, this is not the only opportunity for ANCs to participate. It just is sort of a unique opportunity where ANCs are one of the few bodies that are specifically called out as having to be considered at set down. So that's sort of the focus there.
Great. Thank you, Alex. Were you done, Renee? If so, we'll move
I'm
on.
done.
Okay, we have about 8 minutes left. Ms. Rochelle says, what can neighborhood communities do? We'll have some thoughts about that as Empower, but there's process questions of how can the community get more involved, and who makes up the zoning commission, how they're appointed. Alex, do you want to take a stab?
Yeah, so the commission is the zoning commission is a 5-member body. There's currently 4 members. There's an open seat. 3 are appointed by the mayor with consent of council, and then 2 are representatives from the federal government. So there's currently a representative from the National Park Service and a representative from the Architect of the Capitol. And I believe they serve 4-year terms, if I'm correct. So that's how it's currently composed. In terms of community involvement, I think this is going to be sort of a longer process. I think we would be looking to, work with Empower to sort of continue to get the word out, to continue to get people to get involved in this, beyond the ANCs. So I think that's going to be sort of a longer process of trying to encourage involvement. This is, a lot of this is kind of technical and weird. So, we are available as a resource to help people sort of understand what it is that's going on. So to the degree that after this call, you have questions, your constituents have questions about it, please feel free to reach out to us. But yeah, this is definitely not the end of this. This is really just sort of the beginning of the process.
Great. We've got less than 10 minutes left. Very quickly, Ron, Peter, and I think Sabrina had a thought in the chat as well. Ron?
Okay, thank you. My take is, and it's based on what Parisa said, is that, we're kind of in a conflict of a top-down process, 22-25, and a bottoms-up process regarding racial equity and community involvement, ANC. And I don't see this as you're trying to square a circle kind of situation. So it's a pretty basic disconnect going on in terms of the direction of the text change and what it's actually trying to accomplish. It seems like it's completely at odds. The other thing is, and this is a pet peeve, the word comment, submitting our comments. I've submitted lots of comments, lots of people have, but it does seem like a condescending term to put a comment. It's much stronger than comments. Comments tend to end up in bit buckets. Mm-hmm. So maybe there's an opportunity to look at that term and make it more formidable in terms of what we have to say as input to the process. So also the last thing is, we seem to be talking about OP and kind of their regimen and their processes in terms of their intent. But I tend to think there's other influences. I think we had Chairman Mendelson on before in an earlier meeting. And so there's other motivations to OP higher up than just OP, and that would include the mayor too. So there's a lot of top-down influence going on as well. So, it's probably the origins of this type of change is coming wider than from an OP perspective. That's all I have to say.
Thank you, Ron. Before we go to Peter, I just wanted to put out there, what do people think about people offering comments independently, or us drafting a group sign-on letter for people to sign their names to? There's something to think about. Peter?
Well, I'm all fine with both of your suggestions, Commissioner. I was just going to ask Alex, as just a procedural matter, what do I have to do to sign up for the hearing, the set down hearing, the 29th? And is it useful to have individual ANC commissioners speak? I mean, as with Rochelle or Renee, I can't get a my commission again until like the 24th of October. So, and finally, what our aim should be at this 29th, September 29th meeting. I mean, you've said that this is a long process. I must say, I mean, I've just lived through a small area planning process where we were always told it was just the beginning. Would it be wise simply to object to their doing anything, to advocate that the commission put this off until there's been sort of further public notification of that this is an issue? All to Alex.
So first of all, for Thursday as a public meeting, they won't be taking any oral testimony. It will all be based on the written record. They said they have to consider the ANC report. We'll say it's sort of a gray area as to other comments that come in as to whether they are considered or not. It's not specifically called on the regs one way or the other. So if you are not able to get the ANC, to meet with your ANC to issue a formal resolution, I don't think that should dissuade anyone at this point if you have the time and want to write something and file something to do so. I just cannot guarantee that it'll be officially considered on the record. In terms of the process and sort of whether this should move forward, again, that's sort of going to be the question that the commission is ultimately going to have to decide as to whether this is sort of baked enough to move forward. I think, and again, I think this is sort of going to be based on what they see in the written comments. There are, I think, sort of clear errors or clear questions in some of the drafting decisions here. As I said, there's, just for an example, there's a section which does not include the current regulations. They were changed to reflect changes that were made to respond to COVID and to go to virtual hearings. Those are not included in the current draft. So, I mean, that's just sort of an example of something that's not, I think, objectively like a huge deal, but does mean that, what is being amended in this resolution is not actually the current text of the regulations. In addition to that, the sort of the explanation of what is being proposed and why it's being proposed is not particularly fulsome. There's not an explanation as to, the racial equity impact of this, or, sort of the full logic behind why some choices are being made. So I think that would present a question as to, does the commission have enough information at this point to feel comfortable moving forward with setting it down for a hearing? As I said, that's ultimately their call, but that is, I think there are sort of questions there at this point.
Okay. Good.
Yeah,
Thank you.
I mean, if I could, I just wanted to make sure people understand again that so this is not a public testimony hearing, right? So they will likely glance at the record and see what's in the record to inform their discussion. When they say set down, if they set it down, they will be scheduling a public hearing. So then there would be in the future some chance for public testimony. But I think Peter's point, to me, I would say they should not move forward. To me, this is more bad than good. And our comments, probably should state that this is this should not be moved forward to hearing. It should be left abandoned, no further action. And here's why, and still lay out the problems with it. So if they do move forward to a hearing, the problems are still laid out. But yeah, I mean, I don't really see almost any merit in this proposal whatsoever. So better squash it now than have to mobilize for a hearing later.
Good.
Okay. I believe Sabrina, you said you had a comment in the chat about if all ANCs collectively submitted. Was that the gist? If they all brought the same resolution as collective? Did you have a comment about that, Alex?
So that, I don't really know sort of the logistics, I guess, of how that would work. I'm not saying it can't be done. I would sort of need to think it through a little bit more. So I don't know if there's that's ever sort of happened before where you have sort of a mass of ANCs who have sort of collectively signed on to the same resolution. So that I would want to look into a little bit more before getting back to you on that one.
That's why I was asking, was it an issue for us to do it? I will ask tonight and see if there's an issue with that, but that'd be better to get everybody on board and everybody signed off on the same resolution And they can't turn that away or trash that.
Yeah, I mean, I would say if they move this forward to have a hearing, that would be something we could try to, you know, certainly get as many ANCs as possible to pass a resolution. I think for prior to Thursday, prior to the 29th, that if we just had individual commissioners submit something or sign on to something, that in and of itself, I think there's rarely a lot of public input in the record at set down.
Yep.
The public input in the record at set down might just be from OAG or from, you know, like a developer or somebody, but to have 5, let's say, statements or a letter with 10 sign-ons that represent different communities, I think will be, they will notice that. And it should influence the conversation. And somebody put in the chat, is the meeting open? It's publicized, it's televised, you know, so we'll send a follow-up email and we'll include the links how to view. So you can view the discussion on the 29th. You just can't speak on the 29th. So anything you want to say has to be in writing in the record. And then hopefully they look at it. But on the 29th, there's no public testimony.
Great. Will, can anyone draft the sign-on letter to influence the sit-down?
Yeah, we'll do that actually this afternoon. Paul and I will make sure that we have something that we send to you all. We can do it as a Google Doc so that if there's strong opinions about